Says Michael Popok, Legal AF, following a story that is moving like a locomotive. That's how quickly the appellate court is trying to decide whether Donald Trump committed a crime related to the Mar-a-Lago retention of national security documents and his interaction with the National Archive all the way to the Department of Justice. Because on Friday, then Chief Judge Beryl Howell made a ruling, secret and sealed, but we now have further reporting, that required Evan Corcoran, the lawyer for Donald Trump responsible for all things Mar-a-Lago, Christina Bob's boss effectively for those issues. This is what the judge found, was likely an unwitting participant in a crime committed by the former president related to his retention illegally of the national security documents, the classified top secret documents. In fact, she went on, according to sources that have knowledge, she went on, Judge Beryl Howell, to rule that Donald Trump had a criminal scheme that dated back all the way to the negotiations between his lawyers, him, and the National Archive about the original return of the documents. That led to the subpoena in May of last year by the Department of Justice, in which Christina Bob and Evan Corcoran misled the Department of Justice, said there was only 36 documents when there was another 101 or more at least that were still locked away at Mar-a-Lago. And the judges found prima facie evidence that Trump knew that there were more documents that were at Mar-a-Lago and had at least misled his lawyers. In any event, by finding that there was a crime, regardless of whether the lawyer Evan Corcoran knew that he was being used as a tool in the crime, there was a crime. And if there is a crime, there is no attorney-client privilege for the communication between Donald Trump and Evan Corcoran. Even more amazing reporting that's come out is that Evan Corcoran not only had to turn over to Judge Beryl Howell and then to the Department of Justice off of Friday's ruling, his notes, but that there are audio transcripts of phone conversations between Donald Trump and Evan Corcoran, full transcripts that the Department of Justice is also about to get their hands on because of the order of Beryl Howell. We all know it would lead to an appeal. What we didn't know is how fast this appeal is moving. That's the locomotive part. Normal appeals to the D.C. Circuit Court of a ruling by, let's say, Beryl Howell, which has happened over the last 2 years, could take weeks or even months. This appeal by Evan Corcoran and Donald Trump, combined with another appeal of some other lawyers that worked for Donald Trump, it is moving in hours. The D.C. Appellate Court 3-judge panel, randomly selected, happens to be 2 Biden appointees and 1 Obama appointee, so that's a good panel. They rule, as of last night, that the Trump organization, the Trump defense, has to file their briefing by midnight, Tuesday night, Wednesday morning, midnight. That gave them about 8 or 9 hours to draft up their papers. And they only gave the Department of Justice 6 more hours into the wee hours of the morning, 6 a.m. Wednesday, to file their response. And the issue that the 3-judge panel wants to hear about from the Trump team, they want to hear about what are the documents specifically that Beryl Howell ordered get turned over to the Department of Justice. These notes, these transcripts, these other items that you're arguing over. What are they, and why shouldn't they be turned over on the finding of prima facie crime committed by Trump? Of course, they're going to argue there was no evidence, not enough to meet at least the initial threshold hurdle of a crime committed by Donald Trump. For the Department of Justice, at just a couple hours, from this morning, they wanted the 3-judge panel wants to know from them, why shouldn't we continue to extend the stay that they ordered about Beryl Howell's order, which has been in place as an administrative stay? Why shouldn't we extend it and allow for full briefing, right? Why are we doing this in a stampede way on a fast track? That's the issue for the Department of Justice, and that's their opportunity for the U.S. to talk about national security concerns, the pace at which the Mar-a-Lago grand jury is moving. Like, Judge, we're done with the grand jury. This is one of my theories, and we got to move quickly here. This is the last witness to come in with now a finding of a crime being committed by the judge. committed by Trump found by the judge. So these are the issues that are now at stake. Who is the appellate panel? That's interesting because we've learned in Legal AF, my podcast, and here in these hot takes that judges matter and who the judges are and the composition of these appellate panels matter. And who are they here? Well, I think most of the people that follow Legal AF and this kind of hot take are going to find some comfort in the panel. We have Cornelia Pollard, who was appointed by Obama. We've got Michelle Childs, who was appointed by Biden, and Florence Pan, who was appointed by Biden. You may remember Michelle Childs because she was on the short list for the U.S. Supreme Court and the seat that went to Ketanji Brown Jackson. She was the South Carolina judge originally that Lindsey Graham was pushing Biden to put onto the U.S. Supreme Court, but she's a Democrat appointee and a solid jurist, so we feel good about Michelle Childs. Florence Pan, feel great about Florence Pan, and Cornelia Pollard. And look how fast they're moving. These judges are giving lawyers minutes, hours to file briefing. Normally, as I said earlier in the hot take, this would take months. We'd be talking about this in June, July. We're talking about this in hours, like midnight, 6 a.m. And from there, I expect a ruling by this 3-judge panel sometime Wednesday, maybe Thursday at the latest. I mean, this is going to go really, really fast. Now, let me talk about the prima facie finding by Judge Beryl Howell that Trump committed a crime. That is not the same level of evidence that's required for an indictment. It's not it's not, beyond a reasonable doubt. It's not even at the level where a prosecutor like Jack Smith would immediately move to indict. But it is a minimum threshold level, this prima facie level, that there's enough evidence to state a case against Donald Trump that he committed a crime. This may sound familiar to you because Judge Carter in California in the Central District months ago ruled similarly that Donald Trump and John Eastman worked together to commit a crime and were in a conspiracy concerning fraudulent electors, fake electors, trying to interfere with the peaceful transfer of power when he ordered that John Eastman turn over most of his emails and texts to the Jan 6 committee. Similar ruling. Now, Judge Beryl Howell's ruling, which we've gotten a little more flesh on the bone here, did not completely grant the Department of Justice's motion to get an unfettered testimony from Evan Corcoran to the grand jury. There are 6 categories that Beryl Howell ordered that Evan Corcoran testify to the grand jury. That's an issue that's up on appeal. We don't know exactly the 6 categories, but we're pretty sure that at least one major topic that he's going to have to testify to, unless the appellate court reverses the decision, is about his interaction with Donald Trump about the subpoena compliance. We also believe it's going to involve the videotapes that the Department of Justice got outside the doors of the Mar-a-Lago quote-unquote locked rooms, showing movement of boxes in and out of the rooms at the same time that Evan Corcoran was telling the Department of Justice that everything was safe, locked away, and status quo. Department of Justice, FBI knows that's not true. They've got witness testimony. They've got video evidence. And Evan Corcoran was put in that unenviable position of effectively lying to the Department of Justice, as did his underling, Christina Bobb, who he had sign an affidavit and declaration that, to the best of her knowledge, all of the top secret documents were contained in an envelope with 36 pieces of paper in it, when they knew or should have known, or at least Trump misled them because Trump knew or should have known that there was 100 or more sitting in other parts of Mar-a-Lago. This is the fast-paced rocket of a story. This is what we follow on Hot Takes. We got to do them every day. Sometimes we got to do them every hour. That's how fast the wheels of justice are moving against Donald Trump and those around him in various jurisdictions, whether it's the District of Columbia, Fulton County, Georgia, New York, Manhattan, where we expect an indictment today related to the Stormy Daniels cover-up and the fraudulent books and records issue involving Donald Trump. But we got to follow and follow these stories wherever they're going to take us and bring this kind of clear analysis to our listeners, because that's what they expect. You're not going to get it from mainstream media. You are going to get it from a podcast that I co-anchor on Wednesdays and Saturdays called Legal AF. We're going on tonight, Wednesday night, with a live version at 8 p.m. to cover what we expect to be the indictment and ultimate arrest and surrender of Donald Trump in Manhattan, in the Manhattan DA's office. We'll cover that and all the other civil and criminal cases that involve Donald Trump and are at the intersection of law and politics. If you like my hot takes, I do them about every day on the MeidasTouch network. And you can follow me on social media at MS Popok. This is Michael Popok, Legal AF reporting.
Lock him up. Indictment season is upon us. Celebrate with the new Indictment Season t-shirt and v-neck exclusively at store.meidastouch.com.